Well, good morning, everyone. This is the meeting of the House Judiciary Non-Civil Committee. We're here to consider two bills, House Bill 237 and House Bill 336. We'll start off with House Bill 237. This is an issue that was brought to me by Attorney General Sam Olens and the Department of Law, going to the issue of foreclosure fraud. I think the most efficient thing to do would be to ask the Attorney General if he would come forward and give us some comments on really the fundamentals of the bill. I think what's happening, how does the law not address this, and then getting into how the bill will go ahead and address a need both from a legal perspective and sort of an on-the-ground perspective of what's going on out there that we may not be aware of, and then what tools it is that law enforcement both at the state and the local level need in order to combat a problem. To the extent that you want to invite any member of your team, General Olens, to come forward, you're certainly more than welcome. We're pretty informal here, so more of a dialogue than anything else. And we appreciate your bringing the issue to the House, to this committee, and look forward to your comments.
Thank you very much, Representative Golick. It's a pleasure to be with you all today. During the course,
let me ask you to lean forward if you could and speak
Sure.
in the microphone, just for people who may be watching on the internet.
Sure. Want to thank you for your leadership and assistance in having the bill filed and having the hearing today, as well as this committee's assistance in moving House Bill 200 forward, the sex trafficking bill. Greatly appreciate your help and the leadership there with Representative Lindsay. House Bill 237 is not anti-bank. It literally seeks to solve a problem that is very well known throughout not only our state but this country. There's an unacceptable level of inappropriate conduct by some parties, by a few parties, which has adversely affected public confidence in this state as well as this country. When we sought to come forward with a bill on foreclosure fraud, we sought to do it as narrowly as possible. So what we immediately looked to was the bill that was passed in 2005 by the Georgia legislature on mortgage fraud. At that time, no one frankly thought of the processes that follow the consummation of a mortgage to go through the foreclosure process. So what we sought to do was to literally revise and expand the 2005 mortgage fraud bill to include foreclosure fraud. We have done so as narrowly as possible. We have had continued discussions with the Banking and Financial Institution Committee. It should be made clear that passage of this bill will not stop foreclosures, nor should it. For those individuals that frankly aren't paying their monthly mortgage, foreclosure is the appropriate remedy, and this bill in no way, shape, or form has either a mandatory mediation or other processes that some have encouraged, but which we frankly do not support at the Department of Law. The bill is narrowly tailored to give the AG and DA's appropriate jurisdiction to handle the situation. It does include subpoena power, the same subpoena power that this legislature approved a year ago for the GBI, and that would be both for the AG's office as well as the DA's around our state. With me today are David McLaughlin, the Director of Special Criminal Prosecutions for our office, and Nels Peterson, Counsel for Policy, and they could certainly answer any of your questions in greater detail. But our intent is literally to, as narrowly as possible, solve this issue. Thank you for your time.
Well, we appreciate your being here this morning and making time to address the committee. I guess let me ask if Mr. McLaughlin or Mr. Peterson want to talk to, really to the extent that you can, walk us through, what kind of transaction we're talking about. There's paper that moves from one person and one entity to another person, another entity. What is it? Where's the gap that we're filling with this? With this bill, what are we addressing specifically in terms of, I guess, really the malfeasance that really this seeks to address?
Certainly.
From a sort of a real world example too.
Certainly.
If you can, thank you.
The bill does not seek to address what many observers would call a fairly problematic, convoluted system by which mortgages are assigned and reassigned and sold and bundled and collateralized as mortgage-backed securities in this country, and that is it is a problem. that there's a lot of different people that are trying to address, but it is a big, hard to manage system. And this bill does not deal with that. And the general public perception is there's a system out there that is full of problems. When asked to look at the problem, we looked at it from a criminal standpoint, and we said, okay, well, what really is wrong in the foreclosure system that is a crime versus sort of a fragmented, convoluted system that involves the MERS system and a variety of other programs that are out there. And what we heard being talked about the loudest were the forging of assignments that are used to transfer beneficial interest from party to party following the origination of a mortgage. And there can often be a dozen or more in the course of the history of a loan. And what has happened is over the years, as foreclosures have taken place, and as an interest holder who legitimately, in most instances, has the right to foreclose, seeks to foreclose, they look back over the history of that loan, and there are gaps and holes in the title of that loan, in the history of that loan. And what we saw that has been going on to a degree, and it's certainly not something that all lenders and all servicers are doing, but it has certainly been going on and has been brought to the forefront of attention by sort of this public furor about foreclosures in general, is the creation of assignments to fill in the gaps, backdating, often using notaries that are backdating, forging notary signatures, forging individual signatures. And that's a problem. And we believe it's criminal, and we believe that this legislation will go to the heart of that problem. One of the biggest issues, I believe, with the foreclosure situation is public confidence, I think, is very, very important in having a system that works. The public is entitled to a pristine system. If a person is going to be foreclosed, they're entitled to be foreclosed in a pristine system through a process where all the T's have been crossed and the I's have been dotted. And this legislation will seek to ensure that the lending institutions take serious the problem that we believe has been going on, and will take steps to fix the problem. My hope would be this legislation will be more proactive in stopping crime than it will be a remedy to actually prosecute crime. And we have heard from lenders throughout the state, throughout the country, and I'm aware that some of the representatives are here today, and it's my understanding will acknowledge what I'm saying. There has been a problem, and in large part that problem is being addressed by the institutions. But we want to make it clear, you can't forge documents. You can't create documents because of the convenience that it affords you during an otherwise legitimate foreclosure. And that this bill cuts to the heart of that. And I think it's narrow. I think it's appropriate. And I think it's appropriately located in the residential mortgage fraud statute. And the residential mortgage fraud process is a process that we created here in this building. It's not a magical term, and I think it is appropriate if we see a problem to just expand the definition versus codifying an entirely new crime and calling it foreclosure fraud. I think we can define the residential mortgage lending process as anything we want it to, and I think logically this is a perfect place for it.
Just to be clear, I mean, you talked about the backfilling of documents. You used the word forgery. I mean, these are practices that it's that malfeasance, if I understand you correctly. It's that particular malfeasance which is going to the foreclosure process. In other words, people are being foreclosed upon quicker, for lack of a better term. That foreclosures are being expedited quicker, and they're occurring to people as a result, in some cases, I'm not saying it's uniform by any means, in some cases, due to this particular malfeasance. That, of course, is as I understand it, is a disservice to the borrower because the proper steps are not being taken. There are shortcuts not just negligence, not just sloppiness, but proactive creating of documents that should have been done beforehand, signatures that should have been done beforehand, but they weren't, and they're being backfilled in a nefarious manner, again, on the rare occasion. And that is the end result of that is that borrowers who would not otherwise, some borrowers who would not otherwise be foreclosed upon are being foreclosed upon. Is that a correct statement?
I think that's correct. I mean, we don't have numbers. I would think that anecdotally you could always come up with examples of where there was a foreclosure that took place that maybe shouldn't have taken place. And when you look at the history of the chain of title, you'll find some forged documents. But we're certainly not saying that this problem is causing foreclosures to take place that shouldn't be taking place. I mean, it probably has happened, and just as there have probably been some foreclosures that shouldn't have taken place where there weren't documents that were forged along the chain. One is not necessarily the cause of the other.
But we have a foreclosure process, and that process needs to be adhered to with regard to proper signatures, proper documentation at the proper time. And if we don't, then why even have the law in the books as to what that process is?
Absolutely.
Okay.
And the word that I'll latch on to, because it's been used by some observers as characterizing some of these acts as benign acts, and if they concede that it's fraud, they'll say benign acts of fraud. In other words, it's a foreclosure that could take place otherwise, so the fact that there were benign acts of fraud that happened along the way is really irrelevant. And we certainly don't subscribe to that notion. Just like when we sat down to create this law 6 years ago, the so-called benign acts of fraud, such as on a loan application indicating that it was going to be a primary residence versus a rental property, or overstating your income by $10,000 just so you can clarify or qualify for a loan. Those used to be in some circles called benign acts of fraud, and certainly we didn't see it that way, and certainly all supporters of the original mortgage fraud law did not see it that way.
But in fact, when a borrower goes ahead and exaggerates, whether it's called a benign act of fraud or whatever, just to put it on the other end, when fraud is fraud, and frankly the financial institution relies to their detriment on that borrower putting down truthful information on that application, and that signature they put on there, if that's knowingly false, that in and of itself is a crime. Isn't that true?
Certainly.
So it works both ways, both on the borrower and on the lender. Let me ask you one further question, open up to the committee. With regard to, I'm a little concerned about, and I understand that we've had some conversations with the institutions and the mortgage lending industry on otherwise innocent acts, scrivener's errors, truly innocent mistakes, as opposed to a proactive misrepresentation. And I assume the department would be comfortable with some language, sort of a hold harmless on acts that are truly innocent, truly mistakes. It could have been somebody, a page got stuck together. I mean, whatever it may be. That, of course, is a factual issue. But I just want to make sure that the institutions are fortified in the knowledge that we're not going to be looking to criminalize just simple errors, human error that occurs every day. Mr. Peterson.
And we really appreciate Mo Thrash with the Mortgage Bankers Association and Joe Brandon with the Georgia Bankers Association working with us on some language issues. And to begin with, we don't think that the bill as written applies to innocent mistakes because there's an intent to defraud element that's read through the entire statute. And obviously, if you're making an innocent mistake, you're not making an innocent mistake with intent to defraud. But there is language in front of you, I think that's coming from Mr. Thrash, that we're fine with the addition of one word that I think has been written on there, the word truthful in front of information. And I think that just clarifies that the truthful attempt to correct scrivener's errors and omissions and that sort of thing is not going to be any sort of violation under the statute.
Good. Ms. Bazemore is passing that out right now, and I think it'll be pretty clear to members. It's the potential language for a substitute in Section 3, and I think it'll speak for itself. And I agree with Mr. Peterson's analysis that if you look at it, the reference to 44-14-160 in Section 1 of the bill, all of that goes to deliberate intent to defraud or misrepresentation in some way, shape, or form. So if there's no deliberate misrepresentation or fraud, then this really shouldn't be necessary. But, our financial institutions generally, and I think for the vast majority of the time, do a great job in this state. If this is going to give them some fortification, then there's no harm in doing that either.
Absolutely.
And I think that still it arrives at the objective of the bill. So that's a win-win. Mr. Setzler.
Thank you, Mr. Chairman. To the Attorney General, it's a pleasure to see you in this role. You've been blessed with a great staff. You've made an equally good selection with your counsel, so we commend you for that. Wanted to ask, in practice, how is this enforced? I mean, who's going to raise the issue of these kinds of things happening to get it to the Attorney General's office, get it to a DA so that action can be brought?
I think probably in the way that we are hearing complaints now about the process, and that is primarily people that are borrowers who are going through foreclosure, who are inspecting and using some diligence to take a look at the procedure being used against them, will probably be the biggest source of those complaints.
What ability does is this? And I don't work professionally in this industry, so I have some knowledge of it. But if you're, as a borrower, whether you're a homeowner, whether you're a landlord that owns 5 or 10 properties, or if you're an apartment owner, say you've got a multifamily property that's being foreclosed on, what ability do you have to be part of this process, to see what's happening, to be there reviewing these documents? In practice, I hear that's somewhat an opaque process that the borrowers are often not a part of, to be able to pick up on something like this.
I can certainly not speak to that with any degree of expertise. I think there's probably some people in the room that can. I do know that, going back to my description earlier of what has become sort of an unmanageable, some would say convoluted process, it is an issue. And MERS has been in the media, at least, as being sort of the center point of that lack of openness. And so I think there may be people in the room that could more specifically answer your question. But I know from a consumer standpoint, from a borrower standpoint, from being a homeowner myself, and at times trying to clarify who exactly owns my house, the note on my house, it is difficult. There is no doubt.
Would you contend that there should be some ability for a borrower to be able to review the process as this is happening, to make sure that this is appropriate? I mean, I know that there's been some calls for perhaps some overreach in terms of borrowers being able to force. I've heard calls for forced mediation. I'm not talking about forced mediation, so get that off the table. But would you recognize a need of some kind for borrowers to have some visibility as this process plays out, to make sure that that it's being done appropriately and in accordance with the law?
That there may well be. I think that goes beyond the scope of what we're trying to do and the expertise that we've tried to develop in this particular context, and that may be an issue more appropriately raised in a committee that deals regularly with the ins and outs of banking law, as opposed to trying to do that through a criminal statute. We are very sensitive to the uniqueness of this committee and what we're trying to do in the context of a criminal statute, and we're trying to avoid making corporate transactional law in the context of a criminal statute.
And I believe, Representative Setzler, that Representative Jacobs has been looking at a bill in regard to what you're discussing.
Okay.
And as Nels Peterson stated, we were solely seeking to have a change with regard to the criminal context.
Sure. Again, I'm not suggesting, Mr. Chairman, that we use this as a vehicle to address any of that. I'm just asking from the perspective of the Attorney General, sort of being a outside party that's got responsibility to oversee this from your expertise. Is there philosophically, or is there some need for borrowers who frankly would be the only people that could raise something like this to have some visibility of the process? I just wanted to get your opinion.
I mean, we'd certainly be open to having a subsequent meeting, but it's my understanding Representative Jacobs, in fact, has filed a bill that would expressly relate to the issue that you're presenting.
Thank you, Mr. Chairman.
Mr. Pack.
Thank you, Mr. Chairman. And thank you for your continuous good work on fighting mortgage fraud. I know it's a big problem. Having been on both sides of those type of cases, I know the challenges that law enforcement faces. One thing I wanted to bring up about the subpoena power is I'm a little concerned about in mortgage fraud cases you typically have, it's document intensive, and I would imagine that the Attorney General would subpoena many entities, including loan originators. Obviously, you want the 1004s, and the closing attorneys and the financial institution. And the problem that I see is there's no incentive to kind of limit in scope what documents you want. As a result, I know that it puts a tremendous burden responding to that type of subpoenas. I know it puts a tremendous financial burden on financial institutions, which the costs are passed on to the consumers or the bankers. In the federal system, I know there's a limitation of how much a bank could charge for production of certain documents. And I noticed in here that, and as far as I know, maybe you could educate me on this, there's really no cost containment in terms of if you're asking for everything in the world. And I could see how it's going to be very, very expensive for the financial institution. Is there something that you could tell me that would somewhat make sure that the subpoena is not going to be overly burdensome? And I notice on here in the language on the grounds for objecting to the subpoena, being overly burdensome or broad is not a ground. And I'm just kind of thinking out loud in practice what's that going to do to the responding entity.
Representative, let me first start off by stating the language that we used for House Bill 237 is lifted almost exactly from the legislation that was passed last year, which authorized the Georgia Bureau of Investigation to investigate mortgage fraud and to have subpoena authority. And so to the extent that the subpoena authority is asked to now be given to the district attorneys and the Attorney General, that is not novel. As to the cost issues, I can say that from experience, having been with the Attorney General for 14 years doing criminal work, under Title 45, when the state of Georgia has the authority to investigate crimes involving the state departments and agencies, we do have subpoena authority, and we've utilized that subpoena authority for years without any issues regarding inordinate costs, being unduly burdensome to parties who were seeking documents from, and to the extent that issues have come up, we've always been able to resolve those issues. There is in the banking code a provision that is related strictly to bank records, where financial institutions are limited to charging 25 cents per copy and an hourly rate, I believe it's $15 or something like that. We have never had institutions that have complained about that. Generally, some of the institutions will use that statute and impose those rates when we send them subpoenas, and we've never found that objectionable when they do decide to charge. But I can honestly say in my experience, both with the State Attorney General subpoena authority and the district attorneys when they have grand juries or they have trials where they use trial subpoenas, I have not seen issues that give me any pause to think that more restrictive language is necessary when it comes to subpoenas.
Let me ask a question based in ignorance, which I have no hesitation in doing. As a practical matter, the recipient of a subpoena can go to court and ask the court to limit the scope of that subpoena and demonstrate how it might be unduly burdensome, et cetera. Is that a correct statement?
That's a correct statement, and I've never had that happen. And as a practical matter, being well in touch with most of the DAs in the state, that is not a common thing to have happen when it comes to subpoenas.
Okay.
Well, one of the alternatives is a search warrant, of course. The question then: are you amenable to specifically laying out grounds for what adopting a language for in a civil context? Because the way it's drafted right now in lines 31 through 37, it says it gives the Attorney General power to go ahead and seek enforcement, but doesn't have a provision that allows the recipient of the subpoena to go ahead and get judicial review of the scope and things like that. And I was wondering if you guys are amenable to have adding language in there that allows the recipients to go ahead and challenge affirmatively instead of reacting to a contempt or show cause order.
For my part, I do not think that building into the subpoena process, whether it's this statute or any other statute, having an automatic right of challenge is needed, and it certainly wouldn't further the interest of law enforcement.
Let me just clarify with my colleague, Mr. Pack. This goes back to my question before. So there would, upon receipt of the subpoena, again, my understanding is that the recipient of the subpoena can, on its own motion, upon receipt, can go ahead and apply to the court to limit the scope of the subpoena, as opposed to having some other event occur in the interim. Do you disagree?
Well, as the statute is written, I'm not quite sure where they're supposed to go. I mean, it says,
okay, so is it a venue issue? Or?
Yeah, if you look at line 33, it does address, it says such person may object to the subpoena. So it does lay out grounds to object, but as I pointed out, it doesn't say grounds for overly burdensome or something to limit the scope. So what I was merely suggesting is, I think either way you're going to get to court. The question is either the Attorney General or the District Attorney saying, you didn't comply, we want enforcement, or in that context, the court, obviously the recipient could go to court and say, it's overly broad, Your Honor, but overly broad is not one of the standards allowed under the statute.
But do you have to have that written in the statute? I thought it's implicit that as soon as you receive it, you can go to court and challenge the scope of it, regardless of whether that power exists on the part of the recipient of the subpoena, regardless of what may or may not be in the statute. Is that do you disagree?
Well, I didn't read it that way.
Okay. Mr. Peterson.
Mr. Chairman, may I just suggest that we get with Representative Pack after this meeting, nail down whether the current language adequately resolves his concerns, and if not, we can work on an amendment to fold into a substitute for the next meeting.
Excellent.
Is that sufficient for you?
Yeah, I think it's merely just a language. I have no problems with the Attorney General having power to subpoena, and I think I'm surprised that you guys didn't have power to do this right now. And I'm just a little worried that by specifically putting grounds for constitutional, legal right, or privilege as the only grounds to resist or challenge the scope of the subpoena, that you might be read too narrowly. And so I'll be happy to get together with Mr. Peterson to work on that language.
Very good. Thank you. Ms. Byrd.
Good morning, and thank you. As a non-attorney, I need to go through these steps very carefully every time we go through a bill here. There is an enormous amount of foreclosures going on right now. What triggers someone to believe that there has been fraud from their mortgage loan? I mean, anyone who is trying to save their home is going to try to find some way to hold on to their home. So what triggers them to then begin to think that this is a case of fraud and I really should not be losing my home? Can you explain that to me? I mean, so would every person who is on the verge of losing their home then scream fraud so that they could hang on to their home for another year, 2 years, or however long that may be? Please.
I think some observers would say there is a degree of that is going on right now. I mean, we have a very interesting dynamic right now with the economy being what it is, with an inordinate number of foreclosures, and that number, depending on the day of the week, you hear is going up or is going down. I certainly think it will be an issue for some time to come. And there is certainly an understandable desire for people to do whatever they can do to save their houses. I mean, there's no doubt about that, and we recognize that. And as a practical matter, as I discussed earlier, I think that allegations of fraud will probably come from the fact that there are people that are facing foreclosure and they're starting to look carefully. But as the Attorney General said earlier, this bill is not going to be the thing that prevents foreclosures from taking place in this state. And I think right now we have a dynamic where some people are latching on to these. You hear about the robo-signing, you hear about the forging of documents as being a bar to foreclosure. sort of if there is a bad act, then we win and we get to stay in the house. And that's not what this bill seeks to do. Now, as a practical matter, might there be some instances where it might delay a foreclosure? I think certainly. And as I think this bill and just the discussion of this bill has resulted in the lending institutions being a little bit more diligent in going through their steps, and that has slowed down foreclosures. I hope that when this is all said and done, what we will have are very few reports of actual fraud. I do hope that people in foreclosure will make sure that all the hoops and steps are being gone through. I mean, we would hope that through the process. But I think when it's all said and done, this bill will be proactive and will prevent the lenders from engaging in the fraud in the first place. I think people in foreclosure will always be looking, and they'll be looking for all the signs and the red flags.
But I think just to add to that, the fact of the matter is, if someone stops paying their mortgage and they get a foreclosure notice months down the road, the first thought shouldn't be, oh, there must have been fraud. The first thought should be, well, I stopped paying my mortgage, and foreclosure often follows that. Really, I think the only thing that a homeowner would be able to use to assume that some fraud had existed was if they get foreclosed on a house, the note of which they've been paying, which we don't have more than anecdotal sense has happened on any significant number.
Thank you.
Mr. Atwood.
Thank you, Mr. Chairman. I would like to be included in that conversation with Mr. Pack, because I too had concerns in that area. And frankly, I'm fascinated also that you never had that subpoena power. That's something I've used at the federal level, and I support you in that. But I'd like to work with you a little bit on that if I could.
Absolutely.
Thank you, Mr. Chairman.
Gentlemen, thank you.
Thank you very much.
Thank you, Mr. Chairman.
We appreciate your time, certainly, in coming down and sharing with us. Mr. Brandon, did you have any comment that you wanted to make? You're under no duty, but we understand that we have the language, the compromise language that we have. I just want to make sure that we've touched the base with you publicly.
After 31 years of representing the banking industry, before various committees, never before one dealing with criminal behavior.
That's a good thing.
I will listen carefully to what you just said and pass on making comments. Thank you. But let me say back here, we cannot thank the Attorney General and his staff enough for reaching out to us,
Sure.
Including us, the narrow scope of the language. We'll continue to work in a process. We worked with their office in 2005 to create the original mortgage fraud statute service well, and we look forward to working on this.
Well, thank you for those productive comments. We do well by the taxpayers, by consumers, and by our financial institutions to work on a bill, especially like this, in a collaborative manner. That's the best way to get it right, in my opinion. Mr. Thrash, did you have anything that you'd like to?
Chairman, thank you very much. I want to reiterate what Joe said. We're delighted that the Attorney General has come forward with this legislation. We've been working with he and his staff since day one when they came up with the idea of drafting this bill. They have worked diligently with us, and we're delighted to work with them. We're very satisfied with the language that they put in.
Thank you. I appreciate that as well. Is there any other party or individual like to be heard on House Bill 237? Seeing none, members of the committee, what we're going to do is I'm going to task Mr. Peterson, if I can, to work with Mr. Pack and Mr. Atwood, and of course with Ms. Travis, our legislative counsel, on a substitute that will encompass, at the very least, the hold harmless for an otherwise truthful, otherwise innocent conduct, as per the language you have here, and then whatever other language that may be agreed to between the Attorney General's office and the chair, along with Mr. Atwood and Mr. Pack on behalf of the committee. And then what we'll do is we are going to have another meeting on Monday morning. I think I put a sort of a save the date notice up yesterday. That agenda will be going out this afternoon. I think I think this is pretty straightforward now, and so we'll go ahead and err on the side of being ambitious and add that to our Monday morning agenda. I think we can do that. Ms. Travis, do you feel pretty good about that? Well, no. On Monday, or here? No, we're out of here by noon at the latest right now, and that's a ceiling. So, trust me on that. Okay. With that, let's take 5 minutes while we text Mr. Davis and for consideration of his bill, and then we'll wrap it up after that. So let's take a real 5 minutes if we could. All right, we'll continue our committee meeting this morning with consideration of House Bill 336. Chairman Steve Davis is the author of the bill, and he has arrived. Chairman Davis, let me ask you to pull the microphone to you if you could, and welcome.
Thank you, Mr. Chairman and members of the judiciary. It's non-civil. It's my pleasure to be here and present House Bill 336 to you. I think this is a long overdue piece of legislation that I think that the General Assembly has needed. As a first-year chairman, I've learned a lot on what we can do and what we can't do in the committee process. And I've met with the Speaker and discussed this, and through his attorney, Mr. Riley, and discussed the powers of the subpoena within the Ethics Committee and also MARTOC Committee, and felt like that in our budgeting process, our oversight of the budgeting process, and in our auditing process, that we did not have enough ability to ensure that when we make these decisions that affect billions of dollars and 10 million individuals in the state of Georgia, that we were ensuring that we were getting accurate information. And in such, I felt like that we needed to expand those subpoena powers amongst more committees. And when I started with this, I actually did it for the entire General Assembly. And the Speaker's office felt like we should narrow that scope to a key 7 committees. And those 7 committees will read, on starting on the bottom of page 1, Appropriations, Budget and Fiscal Oversight, Ethics, Information and Audits, Judiciary Non-Civil, Ways and Means, and then the appropriate mirrored Senate committees. And how we structured this legislation is we would centralize the power to actually issue the subpoena in the Speaker's office or at the leadership of the Senate. I put both the President and the President Pro Tem of the Senate on there. The chairman of those 7 committees would solicit or apply to leadership to issue a subpoena or get sworn testimony to those, and then the leadership would decide whether or not that was appropriate to issue the subpoena. And then from there, if the issue was approved, it would go out to the individual or the government agency or department head or whoever the individual or subject of that is. So this is already has the ability on those 2 committees, the Ethics Committee and also the MARTOC Committee, already have this power, and we're really just expanding that power to multiple more committees. And by the way, MARTOC is not listed on there, but they are in a different, they're a statute, a committee of statute in the Constitution, and it's in a different section, but they do have this same power. So, and they do not have to go to the Speaker for such subpoena power. And that's the entire legislation, Mr. Chairman. We can go through it section by section, but that's the entire piece of legislation. We're going to expand the subpoena powers from the 2 committees to the 7 committees.
I know a bill like this, I believe it was Senator Tarver, now U.S. Attorney Tarver, passed legislation similar to this. It passed the Senate, but it rested comfortably in the House, and it had not to do with subpoena, but it did allow for the possibility of compelling sworn testimony as opposed to just testimony in front of a committee, if I recall correctly. So this has some precedent in the General Assembly in the last few years. Just a brief history lesson on that for folks. Mrs. Cooper.
And despite what my colleague thinks, I'm not going to ask for the Health Committee to have subpoena powers. Although sometimes the way the bills we pass do affect people's lives, I would like to have it. But does this mean that the Speaker or the President would have to? I thought when you got a subpoena, and not being a lawyer, so y'all can correct me, you had to show substantial evidence to the judge that you needed the subpoena power? No? You just asked for it?
No, you just issue
So you don't have to show why you need it or anything? I thought there was, okay.
Well, the statute would satisfy that.
Okay, it would elsewhere. Okay.
Yeah, it's not making application of the court. It's being able to issue the subpoena directly from the Speaker's office or the office of the President of the Senate or the President pro tem of the Senate.
So it's actually not going to the court. Okay.
Correct.
Misunderstood.
No.
The only time it would go to the court is if there was a failure to appear
Or if there was a challenge of it, I assume.
or a challenge.
Missed that.
That's why we're here. All right. Don't worry about it. Mr.
Well, I'm not a
Sessler.
lawyer.
No, it doesn't matter. That's why we're asking. You're asking the questions. Mr. Sessler.
Thank you, Mr. Chairman. To the author, we spoke about this last night, and I just I struggle to contain my support for this bill. I think it's needed by this legislature. I think there's been some studies nationally that we have constitutionally one of the weakest legislatures in the nation in terms of the balance of power between the legislature and the executive branch. I think this moving in the direction of what the United States Congress can do recognizes, Mr. Chairman, I would just ask the author to comment, that this is not a power that the United States Congress exercises that much, but it's merely the ability to issue a subpoena that folks willingly come and testify, and the ability to compel sworn testimony once folks do testify really answers the mail. Is that not true?
That is absolutely true, and this will be the exception, not the rule. But just having the power to do it will compel people to come testify and give accurate information, just so we don't exercise that power.
Two questions for you again in the name of housekeeping and getting it right. Is there and I don't know whether other states have this or how it's even contemplated in other statutes. What is the limitation on who can be subpoenaed to testify? I mean, again, as Representative Pack said, the statute satisfies the judge's requirements to be able to issue that. Are there limitations on out-of-state entities that are primarily out of state but have commercial dealings in the state? Are there any boundaries on this? Are there boundaries on United States Congresses? And I mean, if you look at some of the testimony before Congress where you've got Major League Baseball players testifying on their personal habits, I'm concerned at the judgment exercised by the 111th of Congress and who they've had come in. But that notwithstanding, what are the boundaries on this, and what's your intent with who this applies to?
There is no boundaries. We can do individuals. We can use department heads. The inclusion of the budgeting committees and the auditing committees are more of a government function to ensure that the people within state government are giving us accurate information, so we can place an accurate budget out and appropriate the dollars efficiently and effectively. But this does not limit in any manner, just like the Ethics Committee and the MARTOC does now. This can be to individuals as well.
What if the Speaker or the pro tem in the Senate felt like there's a real compelling need to issue a subpoena and have someone come in to testify to the Health Committee or to testify to the Transportation Committee? I'll carry the lady's water for her if she's not going to ask the question. But you could create any set of facts that there's a real need outside the context of these committees. Recognizing these committees are the chairman serve at the pleasure of the Speaker. Most of these committees are creatures of the rules process. Some of these are in statute, others are not. They'd certainly be in statute here. As I think this through, why is there not some ability in this, if there was another committee that needed to get testimony, that the Speaker, or there couldn't be some means to compel someone to come talk to the Health Committee if there was a clear need to do that?
Well, I share that thought, and like I stated, I wished we could do this for all the committees. However, the leadership felt like it was better to target it. I assume that if there's something that's before the Health and Human Services, we could do that through the Appropriations Committee or the Budget and Fiscal Oversight Committee. I mean, if he really is compelled to get them before them and get them to testify in sworn testimony under oath, that can be done through the 7 committees that are there. But he wanted it narrowly tailored, so we didn't have just a broad base that we just pull them in for whatever reason that we wanted. He wanted it tailored to specific items that are within the purview of those 7 committees.
And I just asked the question. I know our speaker has great respect for this committee and the deliberative committee process. I guess I just asked the question: Is there a way to address that concern in a way that might make sense? I'm just I guess asking this sort of parenthetically that we could address that where there's some other ability to or other committees as appointed by the Speaker of the House. So that special committees, special commissions that are created would have that power. I don't know. I'm just asking, and you may be open to that, but I would ask the committee. I'm certainly satisfied. Mr. Chairman, I'd be prepared to make a motion, but I'm asking that to the author and to members of the committee if there's a way we could get at that.
I just think this is the first step, and then we'll see how how this works amongst those committees, and then in future dates, we can always come back and readdress this. But I am wide open to opening it to the entire General Assembly.
Mr. Pack.
Thank you, Mr. Chairman, and thank you, Mr. Chairman, for bringing this this bill. And I think it is an important power to have for developing a record to make sure that our public is heard, and also that the facts are accurate when we're making policy. A couple concerns I would like to point out, and I think you and I spoke about a couple of them. First is I'm a little hesitant to grant the leadership the ultimate discretion without any checks and balances of when to issue the subpoena. And what I'm thinking is, if there is, for example, that committee meets and they debate a motion to issue a subpoena, which I think that's how it works in the congressional level, and then once they vote that motion out, the request goes to the Speaker or Speaker of the House or pro tem, and then they go ahead and affirm or deny and then issue the subpoena. I'm thinking maybe that would allow the public to kind of vet the reason and make sure that it's not viewed as a political motivation of issuing a subpoena to this particular party. Second is, and you and I talked about this a little bit, I'm a little even from the congressional level, and I've dealt with being in the executive committee side, I've dealt with this similar issue of congressional subpoenas or legislative bodies. And in the bill as it's drafted, there doesn't seem to be much involvement from the Attorney General, the executive side. And the reason I bring that up, in the normal legislative process, I don't think there are going to be any problems. But when we're subpoenaing certain individuals, we obviously have to abide by the constitutional rules. When we're compelling testimony of witnesses, particularly like the Ethics Committee, there's some criminal overtones that may be possible. Now, we could certainly have power to compel them to testify. They could always plead the fifth, yet we don't have a mechanism to immunize to get at that testimony, which the federal level does. And in terms of enforcing of the subpoena power in the federal level, as I understand it, the request for contempt is actually made to the U.S. Department of Justice, and the Justice Department goes to court to get that order compelled. And so that way there are some checks and balances, because what we don't want to do is get in a situation we compel somebody to testify and then find out that immunized testimony can't be used or somehow hinder political corruption investigation that's being carried on by the Attorney General's office or any other district attorney's office. So I'll be happy to work with you if you're open to it, to work out some language where the executive branch of the government has some way to know that to the extent that certain testimony witnesses are being, in fact, taken, some kind of coordination
like a notification?
Or some kind of a mechanism where everybody's on the same page here without, encroaching upon somebody's powers. The executive branch, obviously, they're vested with investigating and making sure that the laws are enforced. That and the last thing is, and just kind of a practical matter, and you and I talked about this, if we subpoena for documents, and some of the documents that are either proprietary or trade secrets come into the possession, I know that certain documents that we receive as a legislative body is protected from any kind of discovery or civil litigation, things like that. But I was wondering if we could add some language here to protect, make it explicit that that's not subject to open records, or some mechanism where the person or entity producing the document could designate that this should not be subject to open records. That way, we protect their rights, and yet the legislative body gets the facts that they need.
Well, a lot of times when we're legislating down here, there's unintended consequences. But sometimes we can over-legislate something where we can develop some rules in the House rules or in the Senate rules on the committee process on how we would request it from the committee chairman to the speaker. On the first part of your deal, on the notification, I'm fine with adding a notification clause in there that would notify the governor that we are subpoenaing an executive branch employee or decision making. I'm fine with adding a notification. The compensation on the documentation, I don't know that we should place that in the law, but maybe give some kind of option to the officer that's issuing the subpoena to allow for that if appropriate. I don't know that we put in there that we will, because as soon as we put in there that we're gonna pay 25 cents a copy for a 1,000-page document to someone that you're subpoenaing, every person that we subpoena is going to get 25 cents a copy for 1,000 pages. So I think that when appropriate, if you want to add something like that, I mean, I'm open to that if the committee wants to do that, but I'm hesitant to handcuff us on that, because as soon as you put it in there, if you put on there, a lot of times we'll put in there, well, it's up to this amount. Well, when you put it in there, it's up to this amount, it's always that amount that gets asked for. So I would be careful going down that line, and maybe just when appropriate, the officer may grant compensation for document. As far as the secrecy or the putting documents that we're asking for from an individual, I don't know that that's in legislation now that the Ethics Committee or that the MARTOC Committee does now. I don't really know how we can address that on a transparency fact. I mean, if we're giving sworn testimony before a committee that's being televised and being broadcast across the internet, I don't know how. I don't know how to approach that, quite honestly, Representative.
Let me address a couple things on that. One, Mr. Pax, I thought with regard to committee action, an official committee action to request the presiding officer or the speaker to issue the subpoena, I think is a good idea, because it smacks of sunshine, and that's good, and it certainly inoculates, I would hope, against any sort of political motivation on the issuance of the subpoena. I think that's good. Just technically to counsel, what would that be in the nature of, though? I mean, in other words, the actual document itself. I mean, it wouldn't be in the context of I don't know if it would be a context of a House resolution. Certainly not general legislation. But I mean, would it be voting on something, or is it just create a document, vote on it, members voting for it, sign it, and deliver it to the presiding officer as the committee's open, having been voted on, request to issue the subpoena? I don't think my sense is there's not a necessity for a formal document like a resolution or something like that to be the basis of that. It could just be something written out, it's voted on and open, in an open meeting, it's signed by members, voting for it, and delivered to the presiding officer. I don't think we need to go any further than that, right?
No, I don't think. I mean, I think it could be simply in the form of it could be a discussion and then a form of a motion that the committee wants to ask the presiding officer
Right.
to issue a subpoena.
And then memorialized in a writing, in a letter, and then signed by the members who support the motion or the resolution, whatever we would call it at the time. So I do support that. To Mr. Pack's point about the coordination with the executive branch, I mean, there is a scenario, and there'll be scenarios that we don't think of, that there could be, in conjunction with the issuance of the subpoena, there could very easily be an ongoing criminal investigation going on either at the state or federal level that we may or may not, more likely will not, know about, and rightly so. And so the question then becomes from, and you've seen this at the congressional level numerous times, how a committee will go ahead and issue a subpoena to compel testimony, will seek to go ahead and give immunity to that witness, but that immunity will not be applicable in terms of immunizing that, or it may or may not be applicable in terms of immunizing that witness against the underlying charge that they may or may not be indicted with by a federal or state authority, obviously in the case of Congress, a federal authority. So I'm very sensitive to that. I mean, I say all that to let you know we need to be sensitive to that. Is that really going to be the case? Is it going to be the case where we're compelling testimony, where we're attempting to get somebody to go ahead and go on the record? Should there be even a discussion of immunity, or should we leave it at the fact this person is either going to testify, raise their right hand and tell the truth, or they're going to invoke the Fifth? My sense of it is, just thinking out loud, it's one or the other, and we leave it alone right there. And if they go ahead and plead the Fifth, we let law enforcement deal with it in the sense of their ongoing investigation. I think if we get any deeper on that, getting into immunity, right, I don't think we're positioned to do that here, and that gets. Then I think we're getting into a separation of powers issue at that point, from our experience. I think my sense of it is that we would err on the side of caution. I've not spoken with our presiding officer about it. My sense, knowing him and the time that I have, is that he would agree. But again, I have not had that conversation. Counsel, did you have a?
Yeah, well, I'm a little confused with this swearing part, because I don't see anywhere in this bill where there's sworn testimony to take allowing subpoenas, but I don't think.
Line 23 and 24. Such officer may issue a subpoena to compel before a committee and give sworn testimony or produce documentary.
Okay,
My additional concern, and then to other members of the committee, is that a lot of times we don't have a problem with getting a witness here. Mm-hmm. What we have a problem with is the fact that we're getting lied to. Yeah. That's really it's not having somebody in the chair. We never have a problem with that. Now we could, in a special situation. I think this addresses that special situation. But more often than not, it's the fact that we're not getting the whole truth. Right. According to the truth that person knows but is not providing at the time. And I would ask you to think about the possibility sooner rather than later, because I sense that there's support for this on the committee, subject to various to an amendment or two, for the ability. Because I read it here, such officer may issue a subpoena to compel or any person to appear before a committee and give sworn testimony. Now, we could have someone who wants to testify, but we're not convinced that we're going to get the straight truth from them, and so we want to swear them in. So in that situation, we'd have to issue them a subpoena. And then at that point, they're subpoenaed, they come in, they raise their right hand, and they swear. So you have to have, under the language right here, you have to have both. They're subpoenaed and they're sworn, as opposed to a situation where we don't have to subpoena the person. We just want to get their testimony under oath, under penalty of perjury. So I throw that out to the committee to just think about.
Separate the two?
To potentially separate the two into two separate. If you're having to subpoena somebody to appear, you're putting them under oath, obviously. But you may not have to go ahead and put them under. You may not have to go ahead and issue a subpoena, but you do want them under oath. So just think about that. Let me go ahead and go over here, and then we'll come back around. Mr. Atwood.
Very quickly, Mr. Chairman, I think it's a practical matter, and your concerns are well founded. If it gets to the point where they vote the Fifth or whatever, we can certainly stop at that point and consult with the Attorney General's office and move toward the discussion of immunity if we have to. I think that would be a thoughtful way to do it.
But then we're having to codify. I agree, but then we're in a position of we can have that conversation. Mm-hmm. But then the institutional question here is: are we in a position? Are we truly prepared to enter an immunity conversation with a potential witness?
I agree with you.
That may be. I think we all agree. You got to walk before you can run. Mm-hmm. I'm not sure that we're ready for that.
I'm not saying.
I understand.
I would not be for codifying it.
Yeah.
Is what I'm saying.
Okay.
Mr. Chairman, one point to that, and
sure.
I think.
And then Mr. Sessom.
I think Mr. Chairman's comments are very well. It was a very good observation. I'm just a little afraid that if we allow people to invoke Fifth Amendment without the ability to override that, then you have the abuses of invoking the Fifth, because the ability to invoke the Fifth is very broad. So if you want the testimony, you might not be getting it because they say I'm going to invoke the Fifth, and there's nothing we could do about it. That's why I bring up the whole part about the immunity, not necessarily because I want to make it more complicated than it actually is. So.
And I appreciate the sensitivity there. I go back to what's our end goal here. Our end goal is that if somebody's getting up there and they're invoking the Fifth Amendment, we have a policy question, and all of a sudden you can hear the sound of the screech of the brakes at that point, right? That's a good thing. That's a good thing. Somebody's invoking the Fifth. Holy cow! Right? And honestly, that's a good thing to have happen, because then we know we're heading in a very dangerous direction, and then the process really, if you think about it, has worked, and that we don't have to go any further because we know there's a problem. Just a thought. Mr. Sessler.
Mr. Chairman, you have almost summarized my thoughts in your last 30 seconds comments. I will ask this. A concern of mine was the voluntary testimony that the chairman spoke to earlier. And I do think we should separate to the author the subpoena power with the ability to take sworn testimony. I'll wait on the author. I'm sorry. Would you be open, and would perhaps the committee be open to the voluntary sworn testimony be able to be asked by any chairman? I mean, to me, again, if it's a committee that's not seen as needing to have the subpoena power, if the transportation chairman wants to say, wants to ask someone to swear, give a sworn statement, then I don't see why we would prohibit those chairmen from doing that. Again, separating the voluntaries and the sworn testimony from the subpoena power.
Again, I am open to that
Okay.
on both, and separating it, the subpoena from the sworn testimony, and opening it up to all the chairmen. I worked within the confines of what which I knew we could go to the next level with. But I am, this is a committee process, and I am open to expanding the sworn testimony to all of them if that's what the committee wishes to do. And while I was trying to talk with legal counsel here, was that they're trying to get the documents for the bill for Tarver's bill from a couple of years ago, so we can look at that, and maybe we can make that adjustment.
To the author, a couple of things for us to discuss, and it's probably in the context of a leadership conversation as well, since it's ultimately the committee making application to the leadership. I see we'll need to go ahead and make a change with regard to the formal motion of the committee, an official committee action that serves and delivered to the presiding officer as an application request of the committee for the issuance of a subpoena by the speaker. I think a simultaneous notification of that to the Attorney General is probably a good thing, under the category that if you communicate more, you do better. Just so they're aware, there could be issues that they're aware of that we're not aware of, that they may want to make us aware of. There are issues they may not want to make us aware of for our own good. That's okay too. But that'll be healthy in terms of having an effective process on that. I think we do well to notify the Attorney General's office. There was another issue that counsel brought to my attention on page 3, lines 89 and 90. That we may want to do is, under the assumption that that House Bill 24, Chairman Willard's evidence bill, passes, that those code sections would be changing, and therefore we'd go ahead and strike that code section and then just replace with Title 24 of the referring to the evidence code, so that we don't have a mismatch in the code section numbers. That's a technical change, but it's important, because if we're referring to the wrong section, that's not a good thing. And then of course the matter of, all right, we're going to go ahead and compel pursuant to a subpoena, and then the overall issue of, well, what about just compelling, forget about the subpoena, we have the person here, but we want the testimony sworn. Having two distinct possibilities there, as opposed to connecting it up to a subpoena, and then the possibility of an expansion to other committees in order to compel that sworn testimony, as opposed to the confining of these committees here. Does that sound right?
It does, and how we get there, I'll leave up to the committee process, and I'm open to that.
Okay.
I just, like I was making comments earlier to Representative Pack, I caution over legislating something that would bind us from doing something else later and having some flexibility.
But you do agree that there is something to be, and I'm not putting words in your mouth, my sense is that you agree that our overreaching problem here isn't so much getting the person here, it's getting the truth.
I do.
Okay, and that's what I'm going toward, and that's a conversation above my pay grade that I've got to have, and with the intent of helping the bill. Mr. Sessler.
I'm sorry, Mr. Chair. I meant to ask this before. Didn't have an opportunity to. I lost my train of thought. To the question of the committee process, working before the chairman can make application to speaker, in terms of the power being vested in the committee. I share some of Representative Pack's concerns that the sole discretion for the subpoena not be vested in the speaker alone or the president pro tem of the Senate alone. I mean, to the extent the chairman serve at the pleasure of the speaker, if it's purely a chairman making application to the speaker, in essence, a speaker of the House holds all the cards. I'm just thinking much more broadly than our dear speaker here in 2011. This is a constitutional thing. I mean, or what's the appropriate balance? We had talked before. Does this need to be vested in the whole House versus the committee process? I'm comfortable with the committee process, but wouldn't we be well advised to ensure there be some controls that this power not be at the end of the day vested in any one person? I mean, to the extent the speaker assigns committees, I get all that as well, but I do think there's some protections within our House rules of the ability to take people off committees. That's limited in its nature. I think it's a vital power for the legislature, but it's also an awesome power that's got to be managed and controlled. And
if I could speak to
is that consistent with your approach on this?
Well, I agree with you in part, but know that an individual does have recourse. If they decide that the subpoena is inappropriate, they can challenge it and have recourse through the courts. If the subpoena is not valid and it's not justified in their opinion, they can challenge the subpoena.
Can I take issue with you on that a little bit? And that is that maybe to lawyers and maybe even to legislators, but when John Q. Citizen gets a subpoena, it is a jarring experience. It scares them to death. And to Mr. Setzler's point, I agree that vesting that in one person, notwithstanding the ability to, yes, challenge it in court or move to quash, limit, whatever it may be, yes, that exists, but then, of course, that's money out of pocket and so forth. To me, the issue is really more, it's a balance, I agree, and it has, I think the fundamental goal is to get to the truth, but also to do so in a process that instills public confidence. And that public confidence, in my preliminary opinion, subject to the decision of this committee as a whole, is to have some sort of formal action memorialized by a writing and an action of the committee asking the presiding officer, as opposed to a potential proactive move, by a presiding officer where Mr. Pack's very well-founded concerns could kick in. It's a balance, but it's a balance driven by instilling and maintaining public confidence.
Mr. Chair, one further follow-up question.
Sure, and then Mr. Franklin.
What's your intent with the President of the Senate and the President pro tem of the Senate? Is there an option? I mean, would a chairman be able to, forgive the term, would the chairman be able to shop which officer in the Senate they would make application to? Would it be better to have one? I understand the complexities in the world we live.
that was merely an attempt to be respectful of the leadership of the Senate. And yes, they would be able to shop it to either or.
Mr. Franklin.
Thank you. Since we're getting in and we've kind of hashed that the big issue isn't the compelling the person to appear, but it's to make sure that they're telling the truth when they are here. Would we maybe want to consider the possibility of limiting the subpoena to just government employees, and while we're compelling everyone to give sworn testimony, would that be an option? Just thinking out loud.
Well, I don't know that we went to separating the two, the difference between a subpoena and the sworn testimony. I don't know that we went to narrowing the scope of the subpoena and to compel someone to testify to just government officials. I think we need to leave that a little bit broader personally.
I'm fine with that. I'm not. I just thought that was just a good.
But I agree with the
discussion.
separation of the
Fair
two,
question.
but separating the subpoena power and the sworn testimony. But I'm not. I really don't think that we should do that and limit it to just government employees, but leave it broad based.
Mr. Sessler.
To the
Then
gentleman,
we'll wind it up.
to the gentleman's concern, there's nothing that keeps a member of the public from not showing up here politely in their Sunday dress and saying, "I'm sorry, pursuant to the Fifth Amendment, I'm not going to share anything with the committee." I don't. Am I right, Mr. Chairman? There's no compulsion. If somebody from the public decides it's in their interest not to share, they don't have to share.
No, of course not. But, I mean, under current conditions, sure. Mr. Pack, did you have something else?
There are some balances. I mean, you can't just show up and say, "I'm going to plead the Fifth, so I'm not going to talk to you." You actually have to have a good faith, legitimate basis for invoking that, and you believe that your testimony has a tendency to incriminate you with something. So it's not a blanket resistance to any kind of testimony that would compel. So that's why it's a little more nuanced issue. But I do think, to the gentleman, Representative Franklin's concern, I think limiting to only government employees is probably a little too narrow in scope, especially when we need a lot of things that we need to do as legislators. We need testimony from the public. But I do caution when we're going through the committee process that over-reliance on the Fifth Amendment as the grounds of resisting testimony or a subpoena, I think that's going to be, I think it's going to be, that's viewed a little too broadly.
Let me make sure I understand Mr. Sessler's question from before. The public coming in and just not wanting, I mean, were you speaking in the context of pursuant to a subpoena or no, just like in our current status?
If members of the public were subpoenaed.
Oh, okay. You were I'm sorry.
I was trying to allay Representative Franklin's concerns about members of the public that are living their private lives being subpoenaed to come in.
Oh, right.
I mean, just as a matter of preference, I consider it to be somewhat unsavory that you've got Major League Baseball players being asked to, before committees in Congress, to talk about their use of performance-enhancing drugs or not. I mean, this just may be a philosophical concern of mine. Is that the role of a congressional committee? I don't know. I think that was a judgment call that I might call into question.
Well, it's an inherently political question, and that the remedy for that ultimately is at the ballot box.
Right. And again, Mr. Chairman, I was just saying, Representative Franklin, someone being asked to come in and testify, I don't see that as trampling on someone's rights just because they're a member of the public. That this is and I do think we've got to put the boundaries and protections around this, but at the end of the day, there is some protection in the Fifth to the private citizen.
Not to mention the fact that as a practical matter, were we to go forward, and I take notice of the fact, and I'm sure the speaker does as well, that and I have not done a comparison of the ability of a committee here to compel sworn testimony versus the ability in other state legislatures to do that. I don't know. I've obviously, as we all are familiar with the congressional model. My sense of it is that we're probably a little bit behind other states in that respect, but I think when we take an official action here in this room, which is literally a petition to the Speaker for the issuance of the subpoena, I see that as being very, and I think we all agree that I see that as being very much the exception. I think that's going to be the rare occurrence. And let's say, for the sake of argument, it's not a rare occurrence that there's someone in this chair or another chair at some point who seeks to abuse that authority. Again, having the committee there to act as a backstop, and then the presiding officer as well to exercise his or her judgment, whenever that may be, provides pretty good checks and balances. I would hope.
And Mr. Chairman, I think in the interest of the public, we're talking about this philosophically. I think if the public recognized what I perceive to be the needs of the legislature to really get at issues in a way we cannot now, I think the public's clearly in the balance very well served by this.
Yeah, we just want the truth. That's it. We just want the truth, and I don't think the people that we're privileged to represent would begrudge us that. I think that's their reasonable expectation. They may be, if you watching this right now, saying, "You mean they can't go ahead and do that now?" Right. I'll bet you that's what some are thinking, right? I mean, they can't do that now. That's right, we can't. So this is
some of our
potentially put us on the way.
We could already do this too.
Well, we thought the Attorney General had subpoena power on certain things, and he does not. So it's been an education all around. Let's do this. Let's go ahead and work on that and have some more conversations up and down. And I think realistically we'd probably be looking at Tuesday or Wednesday to give us enough time to go ahead and vet those things out.
I will get with legal counsel as well as Representative Pack and Representative
That'd be
Sensler,
great.
to try and address these issues that we've just discussed.
Sounds good. Look forward to it. Let me tell members we're going to have a meeting on Monday morning at 9:30. We'll go ahead and have the sub on 237 to consider at that time, and the additional agenda will be sent out this afternoon, probably right after lunch. Appreciate your time and your attention this morning. Anything else for the good of the committee? If not, we're adjourned. Thank you.